Good evening to all of you. Yesterday we had a very bad internet connectivity, so we were not able to do things that we wanted to do. And for that matter, of course, essentially what we were doing yesterday was to have a quick revision of some areas of land law. Yeah, was to have a quick review of some areas of land law we think are useful for us to actually include in whatever revision we're doing as far as land law and movable property is concerned. So for that matter, I said, okay, to make it that more meaningful, I thought that maybe if you have some questions to drive your imagination as you explore or as you try to go over the various areas in the land law. Especially so, with respect to the new Land Act, very useful. So just as I told you about like the Constitution, that you should read the at least 10 articles a day. I am also tempted to say that you'll not be doing yourself any harm if you decided to, for example, read 12 sessions, right? 12 sessions of the Act 1036, the Land Act every day. And you have at the more than 20 days before you write the exams. And reading 12 sessions of the Lands Act a day, it will not take you more than 20 minutes, or even let's say if you're even let's say that by 30 minutes you have finished reading 12 sessions of the Lands Act 1036. And if you do that every day, then in my view, you'll be doing a very important aspect of your as far as law of movable property or land law is concerned towards the examination. So just as the 1992 Constitution, 1992 Constitution, I said that 10 articles a day. I said this about 2 weeks or 3 weeks ago. Those who heeded my advice and have been doing 10 articles a day of the 1992 Constitution, I am sure that you have finished the first round of complete reading of the 1992 Constitution, and you've embarked upon the second round, and you should also be finishing very soon. So 10 articles of the 1992 in a day. Now, with respect to the Land Act, Land Act 2020, Act 1036, I will recommend that insofar as they have included land law as part of the examinable models, it will be very helpful if you make a conscious effort to read this whole legislation, in addition to all the news that you have from school and other materials that you get and all the very good textbooks around, including say Dennis James and the other useful land law books. If more importantly, if you could read 1036 about 2 times before the exams, I think that would be good. And how do you do that? You read 12 sessions a day. You read 12 sessions a day. So reading 12 sessions a day, because if you look at it, the sessions are just about 283. So 280. If you were even a little bit more ambitious, we even do 15 sessions a day. So in about 20 days or 18 days, you have finished reading this, I think, about 2 times or something like that. And in addition to that, I will suggest that for purposes of your multiple choice, it is a wise decision if you could pay attention to the interpretation section, section 281, right? Because if you go to section 281, a lot of things are there. If examiner is accepting multiple choice as part of the exams, and if he or she did not want to stress himself so much, just something simple. You just go to the interpretation section. There are a lot of things over there, a lot of pertinent terms and expressions which have been defined there, right? So the person can turn a number of them around and get a very good multiple choice, but which can still trick students. So I recommend strongly that as part of your reading of Act 1036, please read section 281 so that you have a very good interpretation of certain words or phrases which are be given stipulative meaning, which are be given particular meaning by the lawmaker. Okay, so that is very important. So, because like some of the things there are said, you either know it or you don't know it. And some of them, the meaning have also been, if you like, prescribed. And that's why I say stipulative. And for that matter, if you haven't looked at how it is defined in section 281, and you decide to just use a general understanding, sometimes you could get it wrong because they can change the meaning as it were. So for example, if you say that for purposes of a land transaction, an infant means a person who has not attained the age of A, 21, B, 18, C, 16, D, 12. If you haven't, let's say, read the definition of infant in section 281, that infant means a person who has not attained the age of 18 years, you may be tempted to think along how infant when it comes to law of contract, and you go for 21 years and you get it wrong. And if you had, for example, look at the interpretation session and you have walked yourself through the various, you will have certainly gotten it correct. So I seriously recommend that you take that serious. Then quite apart from section 281, section 282, right? Section 282 on the repeal and savings. In other words, which enactment or which legislation that related to land prior to the coming into force of Act 1036, that's the Land Act 2020, that have been repealed, in other words, have been abrogated, is no longer there, and which ones have been saved. So that is why it's useful to look at section 282. And for the ones which are repealed, you must know them on your fingertips, especially for purposes of multiple choice. In case your examiner wanted to be a bit crafty and more creative, and just to dribble you around a little bit. So look at section 282, the repealed enactments, right? Enactments relating to land, which have been repealed by the Land Act 2020, Act 1036, are what we have here. 2821 is a Land Development Protections Act 1960, Act 2, Farmlands Protection Act 1960, Act 107, Land Registry Act 1962, Act 122. And Land Registry Act can easily deceive us if we, for example, we don't read the legislation, that we don't read Act 1036. We're thinking it's still in force. And as you remember, Land Registry Act, that law which created the arrangement for registration of instruments affecting interest in land. And cases like the Asari and Brobe, Intemina Kwanda, Mechanical Lloyd, and I'm sure you remember all those things. That legislation, Land Registry Act 1962 Act 122, has been repealed. And not only that, Administration of Lands Act 1962 at 123. Of course, that legislation which used to set up aspects of the operations of the Lands Commission and all that, that has been repealed. Then State Lands Act 1962 at 125 has also been repealed. And you remember State Lands Act 1962 at 125 was that legislation which provided a framework for exercise of the doctrine of eminent domain, that is compulsory acquisition powers of the state. Of course, that legislation, Act 125, operated alongside Article 20 of the 1992 Constitution. As you remember, Article 20 of the 1992 Constitution is the provision on compulsory acquisition. So, but it is a historical fact that the State Lands Act 1962 at 125 is no longer part of the laws. It be repealed by Act 1036. And not only that, Section 11, the Survey Act 1962, Act 127 has also been repealed. So look at it. It's not the entire Survey Act which has been repealed. So that is the trick. That is why I said that you need to know what is in Section 2A2 on your fingertips. That is the list of enactments concerning land that have been repealed by the new legislation, Land Act 2020, Act 1036. Because if you don't know them on your fingertips and your examiner decided to throw one or three questions in the multiple choice around those type of thing, you get them wrong. But once you know them, you cannot get them wrong. So please look at that. And so with respect to the Survey Act, it's only Section 11 which has been repealed. So let's say that if the multiple choice said that the Land Act 2020, Act 1036, has repealed all the following legislation, except, so maybe like he put some there, right? He put some there, and he would throw in maybe one of the legislation which have been saved and all that. So if the person says that the Survey Act accepts or less without the sections 11, if you don't know 2A2, you struggle to get like the if you like, right answer. So again, the Lands Miscellaneous Provisions Act 1963 at 161 has also been repealed. And not only that, Public Conveyancing Act 1965, that is Act 302, has also been repealed. Rent Stabilization Act, repeal decree, and also Decree 49 has also been repealed. But let me remind you, the Rent Act itself has also been repealed. So to remember that, Act 220, because I don't see Act 220. You remember Act 220? The law which governs the landlord and tenant relationship. So whatever you know with respect to the law which governs the landlord and tenant relationship is still very applicable. And of course, that means that a good number of the arguments Professor Cote made in his article, that is Termination of Leases, published in one of the editions of the University of Ghana Law Journal, are still useful because the Rent Act, Act 220, is not one of the legislation repealed according to Section 2A2 of 1036. So take note of that. So what are the other legislation which we've not mentioned so far as having been repealed? That is the Rent Stabilization Amendment Act, Decree 103, and then the Conveyancing Act, or we used to call the Conveyancing Decree 1973, NRC Decree 175. So that is a major repeal, because that law was in terms of drafting of instruments relating to land. That law was, if you like the very important legislation, but that has been repealed. And of course, those who have been reading Act 1036, you will notice that the relevant portions of the conveyancing decree have been reworked into the new provisions of Act 1036. So let's take note of that. And related to that, the Public Lands Protection Act 1974, NRC Decree 240 has also been repealed. And then, of course, the well-known and the almighty PNDC Law 152, that Land Title Registration Act 1986, has also been repealed. So, as I said, these are matters that you have to do a little bit of like a memory work, do rote learning, and know the list. And the reason for that is just to be able to navigate your way. Should there be one or two multiple choice questions, let's say, around that? So that is the point. And then quite apart from that, I will also suggest that we have to look at the transitional provision. You know, when you have a law, especially a law which is supposed to be a consolidating legislation. And of course, we should know that Act 1036 is a consolidating legislation. And when I say consolidating legislation, maybe let me remind you of some of the things that we have like in the Ghana legal system. A consolidating legislation is a piece of legislation which tries to synthesize, that is, bring together, put together scattered legislation on essentially the same subject matter or a common thematic area. If you have scattered piece of legislation here and there, but all pertaining to a common thematic area or pertaining to the same subject matter, a time may come that the lawmaker may say that let us rationalize, let us simplify the law and bring all these scattered legislation together and try to iron out any internal inconsistent traditions. We harmonize them. And that is exactly what the Lands Act has sought to do. And for that matter, if you look at what we call the long title, right? If we look at the long title is just a page. That is after the short title, Land Act 2020. So just beneath that, you notice that it is stated, in quote, an act is to, it should have been an act to revise, the ace is not, an act to revise, harmonize, and consolidate the laws on land to ensure sustainable land administration and management, effective and efficient land tenure, and to provide for related matters. So that is a consolidating legislation. And since a consolidating legislation, there'll be need, of course, for some transitional provisions. In other words, between the phasing out of the old law or the old legal framework and the operationalizing the new regime, how do you manage that? So that is because of the transitional provision. And that is why, if we look at, and this point I'm making is important too, even when we are doing a problem-based question, right? Especially section 283, and listen to 283.1, what it says. An application pending before the Lands Commission, before the coming into force of this act, shall be processed by the Lands Commission in accordance with it. So meaning that if someone, for example, had purchased a land and the person has submitted his list or sublease or assignment or any instrument affecting interest in land to Lands Commission for same to be processed. And let's suppose that that had been submitted and had been pending before the coming into force of Act 1036. And eventually, Act 1036 comes into force. So question is, what happens to the applications for registration, which had been submitted? And that is where section 231 will become necessary. And of course, you remember the confusion created by cases like Intem and Akwanda, and then later on the Asari and Brobe and all that. So section 2831 transitional provision like will tell us what the situation should be. And again, with respect to competition, right? Especially when it comes to the State Lands Act 1962 at 125. Section 283, subsection 2 makes the point that the provisions of that act shall apply to a compulsory acquisition of land which commence before the coming into force. And that is another reason why you should look at the 283. So, you know, the State Lands Act at 125, prior to the coming into force of Act 1036, it was that legislation which supplemented the conditional provision of Article 20 in relation to compulsory acquisition. Of course, if there were some inconsistency, since it's an existing law, Article 11, Article 11, clause 5, then it will have to be brought in line with the letter and spirit of the Constitution. Now, let's suppose that some measures or some policy intervention have been made by the government that yes, we want to compulsorily acquire these lands and that land. And the process for the compulsory acquisition, for example, have been going on before the coming into force of Act 1036, but it was not completed, and Act 1036 has come into force. So what will happen to the issues that arise with respect to compulsory acquisition, which have been going on? And that is why section 2832 saying that the compulsory acquisition which had commenced before the coming into force of Act 1036 will not be governed by the new regime. You know, yesterday I told you that the extensive procedure on compulsory acquisition under the new law, I mentioned section 240 to 249 of Act 1036 that prescribes the procedure for doing compulsory acquisition in Ghana, or for the state to exercise its eminent domain. Now, per section 283 of Act 1036, which I've just told you, if some compulsory acquisition process have been going on before 23rd December 2020, when Act 1036 actually came into force. Now, that compulsory acquisition, which have been going on, will continue to be governed by the old law, the repealed State Lands Act, 1962 Act 125. So let us keep that in mind. And finally, another final point with respect to transitional issues, I mean, between the old law and then this new law, Act 2020, Act 1036, is what we see in section 283, subsection 3, quote, that within 1 year after coming into force of this act, that is the Land Act 1036, a person who has registered land in the name of an infant shall ensure that that person registers land in the name of an adult as a proprietor in trust for that infant. Of course, yesterday, some of the questions which you were given require you to also discuss some of the novelties or some of the new features which the new law has brought up. So please, these introductory or preliminary remarks are, I think, very important, and I would just, the risks of being repetitive, I would say that read at least 15 sessions of Act 1036 a day, and you'll be able to finish reading that. And also pay special attention to the interpretation section 281. And my reason for emphasizing that is just to avoid you being aware as far as some of the multiple choice is concerned. And again, I've also said that you should know enactment or legislation which have been repealed by Act 1036. And for that one, I recommend that you know them on your fingertips so that if you are dribbled by any question, you'll be able to get the right one. And finally, I said the transitional provision, you should pay attention to them. Okay, so, and if, yesterday I told you that Sir Dennis did a very beautiful lecture to the Ghana Academy of Arts and Sciences. That is his inaugural lecture as a fellow of the academy. And he decided to reflect on the trends in land law and then land administration. And of course, the bulk of his reflection centered on the new Act 1036. So he has made available his script to me for purposes of learning and revising with you so that at least as far as the new law is concerned, you will be able to deal with things. Okay, so just a very quick, over what I am particularly interested in terms of the laws which were enforced before the coming into force of Act 1036. I have just discussed them, so we will not waste time on that. So what are, and let's pay attention to this as well, please. If you can see my screen, you can see my screen, yeah. So let's pay attention to this aspect. That is the acts or enactments on land still in force. In other words, yes, having been aware of enactments concerning land that have been repealed by the Land Act 2020, Act 1036, do we know other enactments or legislation relating to land which were not repealed or which were retained or left intact by the Land Act 2020? So these are the Towns Act 1892, Cap 86, Land Statutory Will Leaves Act 1963 at 186, and of course the all famous Limitations Act, which is called the Limitation Decree 1972, and I say Decree 54. And if you don't remember anything at all, remember the doctrine of adverse possession. And the adverse possession is enacted by the Limitations Act, that if you've been in adverse possession for 12 years, then that could, if you like, extinguish the title of the person who has acquiesced in your adverse possession for the stated period. And again, the Mortgages Act 1972, NRC Decree 96, has also been retained, meaning that it has not been repealed. It has not been repealed by Act 1036. I think there's another legislation which is not included in the speech, but I think that if you look at the law, that has also been retained. That is what we call like the Rent Act. The Rent Act, what we call like the Act 220. So that has also been retained, meaning that it has not been repealed. So let us take note of that. Then he said just a few words about each of these legislation. But the Towns Act is a colonial legislation. That is why we call it the CAP. It was an ordinance. It was just changed into an act as a result of the the work, the revision of the laws of Ghana by the venerable late VRAC Crab. And that ordinance, that is the Towns Act 1992, just related to the streets, the making of streets, creating streets, enlarging them and all that, and how to provide compensation to people that may have in land in respect of which streets were going to be expanded to. So that is about that. And then the Land Statutory Way Leaves Act, 1963, at 186, is also a legislation which authorizes the president to acquire, just to acquire land for purposes of function of public utility, maybe electricity, water, gas, sewage, or any telecommunication facility and all that. So that is the Land Statutory Way Leaves Act. That is what it seeks to do. As we have stated, it's one of those legislation that have been retained and were not repealed by Act 1036. And of course, the well-known the Mortgages Act 1972, NRC 96. We know that it is the law which deals with the mortgages in relation to immovable property. And you know that in Ghana, we don't have like the mortgage in relation to movables. So just in relation to immovable property. So it is still retained. And all the things that we've learned about mortgage, mortgagee, mortgagor, and all that. And you need to, you can have judicial sale of a mortgage if it has been registered and all that. All those things are still part of the law. And as we know that legal ownership and possession of security remains in the mortgagor until the mortgagor defaults in payment. And remember, there used to be a common law rule, what they call the principle in Santley and Wild, or the doctrine in Santley and Wild, which require if you're going to have like a mortgage, then the person who is the owner of the property will have to transfer the ownership to you and all that. Now that has been abolished, and that is not the law in Ghana. The person creating the mortgage, that is a mortgagor, does not have to transfer his property to the mortgagee. No. And that is why a mortgage is understood as an encumbrance. An encumbrance is like a charge on the particular movable property which you are using as a mortgage, as it were. So let's keep that in mind. And interestingly, if we look at the interpretation out of Act 1036, if you look up, I mean, if you go to section 281 and you wanted to look at the meaning of mortgage, it says that mortgage has a meaning assigned to it in section 1 of the Mortgages Act 1972, and I said Decree 96. So meaning that the definition of mortgage in the Mortgages Act, that is an encumbrance, is still very much the law. It's not been repealed. So NRC Decree 96 is still part of the laws. And then limitations act, as I have indicated, is relevant with respect to adverse possession. That where a trespasser has been on another person's land for 12 years or more, then that could extinguish the right or the interest of the original owner, who was cognizant of the presence of the trespasser and has acquiesced in his being there for all that 12 years. Good. So what are the changes which have been made by the Land Act 2020 Act 1036? Of course, as you'll be reading this, these have been quite obvious to you, but there is nothing wrong for us to benefit from the discussion of Justice Denise J's beautiful paper, which we are looking at. And as we have noted, the Act 1036 is a consolidating legislation, and not just ordinary consolidating legislation, but more importantly, it addresses aspect of customary law. So customary land law, which has been based upon just a judicial decisions or decided cases, a long time has been given extensive treatment in a legislation. So that is very important. And again, if you look at Act 1036, the various types of freehold interest in Ghana has been maintained. And the allodial title, which we know as the highest title or the paramount quantum of interest, which one can have in a land, is still very retained. Then the customary law freehold is also retained. And then the common law freehold is also retained. But as I said, if you look at maybe the authors like Oleino and Woodman and co, you notice that customary law freehold used to be interchanged with usufructuary interest. But I think if you look at the section 1 of Act 1036, in the listing of interest in law, interest in land, I think that has been made to stand on its own. If not because of time, you could contrast the listing of interest in land in section 1 of Act 1036 with section 19 of the repealed land title registration law, PNDC law 152. Yeah, but one thing we should know is that this new act, that is the Land Act, has made important changes in the law. For example, if you take the freehold interest, customary tenancies and all that, a lot of new things have been developed, and especially accountability regime for fiduciaries. We'll be looking at some of this, although because of the, so let's just take one and just say a few comments. And in the questions that I suggested, for example, you could also be, let's say, invited to discuss the customer, or just discuss interest in land in Ghana and demonstrate any changes or modifications that have been made by the new legislation. So like a typical discussion of the interest listed in the section 1, which are the range of interest one can have in land in Ghana and all that. Then you have to know the pre-Act 1036 position and now the Act 1036 position. So that is very important. So if you take freehold, for example, some changes have been made in how you acquire the freehold. Now, at customary law, we know that the highest or the supreme interest in land was the allodia. And this allodia title, according to Ohimen and Ajay and all that, were held by the Sioux or the Skin or the Clan. And it was acquired through 4 main ways, if you like: conquest and settlement. You're able to defeat people who were there, and then you don't just defeat them, but you also settle on it. So that's one. Or pioneer discovery. A hunter or somebody went on hunting or something, and you go to a place and very nice land there, nobody is there, you go and tell his people and then they come and live there. Or settlement, so you discover it and then you settle on it. Or it could be purchased or it could be gifted. So these were the principal or the traditional ways of acquiring allodia as the highest interest in land. But if you look at the new law has actually, if you look at section 2, right? If you look at section 2 of Act 1036, the state as in Republic of Ghana, certainly not the state as maybe like the Oman or something, like Oman as maybe the Ekwapiman, Asantiman, or whatever. No, we're not talking about that kind of state. Of course, customary law, state will have mean like the Oman, but with respect to section 2, we are not talking about that. We are talking about the state as in the Republic of Ghana, so to speak. So if you look at section 2 of Act 1036, you notice that the Republic, that is the state, has been included as one of the entities which can hold allodia title. And how does the state acquire allodia title? The state will acquire allodia title according to section 2 of Act 1036 through compulsory acquisition. Through compulsory acquisition. Of course, the other things which have been stated there, the only thing which will apply to maybe the state will be, compulsory acquisition, certainly. All the others will not apply to like the Republic, like the conquest, pioneer, discovery, and settlement, gift, purchase, or agreement. So where the state has compulsorily acquired interest in land, if, for example, what it compulsorily acquired was like the allodia was there and all that, automatically, what it means is that the state is now going to become the repository of the allodia title with respect to the particular land which it has compulsorily acquired. So that is one thing that we should keep in mind. And that is why His Lordship, the Mr. J, will make the point that compulsory acquisition by the state will definitely deprive the allodia owner of his title. And that is why the state will now become the repository or the holder of the allodia title in respect of the land which has been compulsorily acquired. But there is a very interesting dimension. Now, if you look at the law, right? If we look at the law, the state is required to give the person, like if the state, for example, having compulsorily acquired the land, does not have the need of it or does not use it, the state is supposed to give the first option to the person from whom the land was originally acquired. But the point has been made that despite the fact that, one will argue that if the state will have to give like the first option to the original owner, does it mean that the allodia title will go back to that person, or the state will retain the allodia title? Well, if you look at the law, the state will still retain the allodia title, despite the fact that if the state will have to retain, like will not have land for the purpose for which it was acquired, the original owner will have to be given the first option, but the allodia title will still vest in the state. So maybe the person who is having the land returned to him will get something lesser than the allodia title, as it were. And of course, we also remember supervisory interest. The fact that if, as customary law, you were a member of the stool or the family which has the allodia title, then you had the right to reduce portion of the land to your enjoyment, subject to your strength and wherever you be able to wait up to and all that. And we know that at customary law, virtual interest is inheritable, meaning that it can pass on just like any other property, which can devolve according to principles of succession. And of course, it can also be alienated. It can be transferred as it were. Now, if we look at the case law, the impression was made that in terms of duration, that the usufructuary interest was practically or potentially of a perpetual nature like the alludia title, so to speak. The only caveat was that if the person who held the usufructuary interest, for example, committed some customary breaches, or you deny the title of the alludia owner, of course, then that one you forfeit your interest. That was the only thing. Now, if you look at, I mean, the last point on this, if you look at section 50, let's quickly go to section 50. Section 50 of the, yeah. Section 50, 1036, actually governs what we call implied covenants by transferor. If you remember, conveyancing decree or conveyancing act also used to have what they call the implied covenant, but that one has repealed and it has been subsumed in section 50. If you look at section 50, subsection 21, right? Subsection, we can even expand it. Let's start from even like the subsection 21, that a holder of an alludia title may A, in furtherance of the expansion of a town or settlement, and B, for the purpose of serving the communal interests of the beneficiaries of the alludia interests, take over bare land or farmland, which is the subject of a usufructuary interest within the area covered by the alludia title. Now, ordinarily, if you take what we call the case law, you notice that alludia alludia title holder could not dispossess a usufructuary title holder, meaning that yes, you have the alludia title, but you cannot just truncate the usufructuary interest. But in the new law, if you look at Act 1036, section 50, subsection 21, is reminding us that insofar as the alludia title holder is going to use the land in respect of which is usufructuary interest for communal interests, right? For communal interests or for communal benefit, then it can interfere with the usufructuary interest. So that is the point about section 50, subsection 21. And if you look at the subsection 22, the point is made that the holder of an alludia title shall not take over land under subsection 21 without A, prompt payment of fair and adequate compensation, which in any case shall not be less than 40% of the plots of land, the market value of the plots of land being taken over. Or you see that this is a very novel provision. It's a new thing which has been added to our law. So that the alludia title holder is more or less exercising aspect of what is called the eminent domain, compulsory acquisition, that of course, we know who is the allodial title holder most of the times. It's usually like the stool or like the family. And then we are being told that where the allodial title holder, as we saw in 50 subsection 21, for example, requires to expand the town. Like the town is population is growing, you need to have town expansion or settlement expansion, or you are using it to serve the communal interests, to serve the general good or the beneficiaries of the allodial. You can do compulsory acquisition with respect to the usufructuary interest, so to speak. But there are safeguards that the usufructuary interest holder is going to be compensated. And that is why Section 50, subsection 2 is saying that the allodial title holder cannot take over the land in respect of which a usufructuary interest is held, unless he is prepared or they are prepared to pay, to make prompt payment of fair and adequate compensation. And there's a guideline that what will be considered as adequate compensation should not be less than 40% of plots of land or the market value of the plots of land. And usually what happens is that the usufructuary interest will be maybe like, the person may be farming on it, right? You go to our countryside, you are farming on it, the town is growing, the chief and the people would like to convert farmlands into building plots. So that is where Section 50, subsection 21 and 22 become relevant. Or, quite apart from that, you can provide suitable alternative land to the usufructuary interest, and that will also be considered fair in terms of safeguarding the interests of the usufructuary interest holder. So here, you see that it's a good thing, right? It is a good thing being added by the new law to the land law. Especially so, we've seen a lot of confusion when towns are expanding, and there will be a clash between those who have usufructuary interests in various farmlands and all that, which are needed for town expansion. But now there's clarity, there is certainty. And what I have just discussed with you is an example of the certainty which the law is actually bringing onto the table as far as land transactions are concerned in the country. And I think is a good thing. And of course, as His Lordship, Justice Dennis, makes the point that as the implication of Section 50, subsection 2021 that we'll be seeing is that the original customary law position has been modified or altered. And what that means is that most of the, or some of the decided cases governing how and when the allodial title holder could, for example, interfere with the usufructuary interest holder's land, rendered irrelevant or unnecessary, because the Act has introduced more certainty, and you don't need to actually look to sometimes conflicting authorities to know what their position is. So all these points I'm canvassing could be harnessed to answer some of the questions that I put up yesterday, and I've also uploaded with the recording on the YouTube. And in terms of the merits of some of these like developments or the advantage of having this particular radical change, one would argue that okay, somebody is asking a question. Okay. Well, can a beneficiary of land given under grant from a family land lose his land without that consent from the family? Also, can he lose it if he disagrees with the family in court case when he testifies against the family support? I mean, this one, you need a rare legal advice on the pending case. Okay, we can talk about some of these things. You have mine. We can just WhatsApp and discuss this unique type of scenarios, not necessarily needed for immediate examination purpose. Okay, so we can talk about that, but let's move on with our discussion because we're running for quite some time and you need to go to bed. I think about 30-40 minutes I'll have to end so that you can go to bed. Yeah, so I was just trying to highlight the advantages of some of these development that as far as town planning is concerned, this new development is very good because you are not going to have to struggle to be able to do necessary rezoning to cover farmlands and all that. And of course, it also will bring an end to the litigation, right, which we often see. If you look at most of the litigation on land in court, I will tell you that most of them will have to do with the expansion of a town or settlement, right, into the outer part of the town, like where farming or some other things are done. And then those who were on the land will go to court and say that, no, you cannot convert it into building plots. Then the chief will say that, no, the town is for us, we can convert it and all that. So section 50, as we have discussed, section 50 actually come to resolve most of these problems, and it will certainly minimize litigation. So let us also look at the customary tenancies, and then we'll look at how Act 1036, that is the Land Act, has actually impacted on customary tenancies. Now we know that customary law recognize tenancies in the two main types, which we have, of course, and all of them based upon the agreement that you farm, and then we will share the process according to agreement. Now, we have the Abunu and then the Ebusa, which we all know very well. And by the Abunu, what it meant was that the parties were not supposed to physically partition the farm into two. It doesn't matter that that was what the parties agreed upon. The case law, right, or the courts, through cases like Akrofi against Resi, came to emphasize that if you have a customary tenancy agreement, that is an agreement for someone to farm on your land or cultivate your land and all that. And if there was any clause or there was any understanding that there was going to be physical sharing of the farm, that agreement was supposed to be void. And the reason the case law gave was that customary law did not know of, customary law did not know of physical partition. All that it knows of the sharing of crops. So customary tenancy was synonymous with sharing of crops and not the farm. So it's not the fact that like a farm and then when the farm is matured, we will split it. You take half of the farm and then I take half. No, was not the customary law position. Now, if we look at Section 7, right? Section 7 of the Act 1036. Section 7 addresses what we call like the customary tenancy. So if you look at the Section 7, Section 7 sort of give primacy to intention of the parties. So I will like us to look at the provision itself. So Section 7, a customary tenancy, A, is an interest in land which is created by a contract, so it is contractual. B, arises where a stew or skin, clan or family which holds a allodial title or person who holds a customary law freehold or is virtual interest into an agreement with another person to grant that other person an interest in land upon agreed terms and conditions. And C, may involve the payment of rent, the sharing of the produce of a farm, or the physical partition or severance of the farm or land. So if you look at Section 7, you notice that Section 7 has given primacy to intention of the parties. If it was the intention of the parties that the farm will be shared physically, there will be physical partition and not just the produce, so be it. Because, and that is why Section 7 is emphatic that customer tenancy is contractual. It's based upon agreement. So if it's based upon agreement and the parties have really negotiated that, yes, do the farm, I'll provide this and this and that, seeds and all that. When the farm is ready, you get a surveyor to share it into 2 equal parts or whatever parts, as the case may be. That should be permissible. And that is what Section 7 of the Land Act is seeking to do. And that is why that says the Nizadir rightly says that this is a better development, because if you look at the case law which we have seen, there were some conflicting position. Some cases will say that customary tenancy is only about sharing of the produce. Other cases will say that no, if the parties own the physical partition of the farm, that should be permissible. Now, all those controversies have been put to rest by the position which have been enacted of Act 1036, that ultimately it is what the parties intend which matters, and that could be sharing of crops, or that could be a physical partition of the farm, as it were. So let's take note of that. I think another area which is worth noting is the. But before I move on, with respect to the various customary law interests in land, I am particularly interested in you paying attention to Section 8, right? Because Section 8 makes the point that, quote, subject to Sections 2, 3, 4, 5, 6, and 7, the bundle of rights and obligations that attach to any form of interest in land shall be determined by the applicable source of law, which is the basis of that interest. Now, if you are going to answer one of the questions that I gave, I think it is important that you think about Section 8. What Section 8 is saying simply means this, that if you start from Section 1 of Act 1036 up to Section 7, the various interests in land, right? The various interests in land, especially the customary law interests in land, have been adumbrated or have been listed from Section 1 And then you go to section 2, it will just briefly tell you about loader title. Section 3, customary law freehold. And then section 5 is virtual interest. Section 7, customary tenancy. Now, what section 8 is saying is that apart from these specific provisions, right, on those stated customary law interests, all the other things which we know about those interests as developed under customary law, as per the various judicial decisions, are still important. And that is why it says that the bundle of rights and obligations that attach to any form of land shall be determined by the applicable source of law, which is the basis of that interest. So let's keep that in mind. Now, in terms of the restriction on acquisition of land by non-citizens of Ghana, I think we have to pay attention to section 10. And that provision is important, especially so if you have to do a problem-based question, just like you are giving like a problem-based question and you see like a non-citizen in it, and the person will need to acquire like an interest in land. I think it is important for us to know the boundaries in terms of what the law permits and what the law does not permit. So I think that we can, it's now 10:23. So because we go to work tomorrow, and you know, the University Teachers Association of Ghana, we are still on strike. So I have a bit more free time. And the lawyers, so we are on the legal vacation of the Superior Courts. So what I will do is that tomorrow in the course of the afternoon, I will come online and continue with some of the discussion. And then in the evening too, we do another 1.5 hours. So I would like to draw the curtain down on the tonight's class. Yes, so have a very good night.